Welcome to the Mid-Wilshire Disability Discrimination Guide for Corporate Employees. This guide explores subtle forms of discrimination in Los Angeles offices and highlights California's Fair Employment and Housing Act law, which mandates reasonable accommodations unless undue hardship is proven. Disability discrimination is prevalent in Los Angeles corporate offices, especially in Mid-Wilshire's media and financial sectors. Despite strong California laws, many employees are unaware of their rights. This guide explains what discrimination looks like, applicable legal protections, and steps to safeguard your career and rights. Disability discrimination involves adverse actions against employees due to disabilities, including temporary conditions like migraines or anxiety. In Mid-Wilshire, discrimination often appears subtly, such as denying promotions or accommodations. Even well-intentioned actions can be discriminatory if based on disability. Documenting incidents meticulously is crucial for legal protection. California's Fair Employment and Housing Act offers robust protections against disability discrimination, applying to employers with 5 or more employees and covering a broader range of disabilities than the Federal Americans with Disabilities Act. Employers must provide reasonable accommodations and engage in a timely, good-faith interactive process. Failure to do so can lead to significant legal liability. California's Fair Employment and Housing Act applies to employers with 5 or more employees, offering broader disability definitions and stronger accommodation duties than the Federal Americans with Disabilities Act, which applies to 15 or more employees. Remedies under the Fair Employment and Housing Act include emotional distress, enforced by the California Civil Rights Department. Employees should request accommodations in writing, engage in the interactive process, and consult an attorney before major decisions. Disability discrimination in corporate settings often unfolds subtly. After disclosing a diagnosis, employees may notice shifts in management tone, reassign projects, or exclusion from meetings. Overt discrimination includes direct rejections or mockery, while subtle forms involve vague performance reasons or unfulfilled accommodations. Document every incident, save communications, and follow internal complaint procedures strategically to build a legal record. Document every incident immediately, noting details like date, time, and participants. Preserve all written communications by forwarding emails to a personal account or printing them. Request accommodations in writing and follow up verbal discussions with email summaries. These steps are crucial for protecting your legal rights and strengthening future claims. File an internal human resources complaint to create a formal record. Consult an employment attorney before major decisions. File a complaint with the California Civil Rights Department within 3 years. Quality documentation is crucial. It counters employer claims of performance issues. Understand your medical leave rights. Always follow up human resources discussions with a summary email. The Westwood Disability Guide emphasizes the importance of early legal advice. It empowers you to make informed, strategic decisions rather than reactive ones. Proactive advocacy is crucial to protect your career and dignity. Connect with Shirazi Law Office for strategic representation against disability discrimination in Mid-Wilshire corporate offices. Understand your rights under the Fair Employment and Housing Act and the Americans with Disabilities Act for comprehensive protection. Document incidents promptly, report to Human Resources formally, and consult a qualified employment lawyer for legal options. You cannot be fired for requesting disability accommodations. It's illegal under the Fair Employment and Housing Act and the Americans with Disabilities Act, and retaliation may lead to additional legal remedies.